Okay. Welcome to the rainy planning zoning meeting for August. You see, sorry, September 18th, 2024. Okay, so we should have a roll call
Mark Hum,
here.
Juan Cotton,
Here.
Zaid Shamsi Basha,
Here.
Dan Waleski,
Here.
Dave Matthews,
Here.
Henry Polsky.
Here.
You have a quorum.
Okay. I'll stand up for the Pledge of Allegiance, please. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay, any additions, deletions, or reordering and approval of the agenda?
No, Mr. Chair.
So the approval of the minutes for August 7th.
I move to approve the minutes from the August 7th meeting.
There's a second.
Second.
All in favor?
Aye.
All right. Cases. It seems like we have some interesting things happening today. So I'd like to swear in the staff and any applicants, affected parties as well.
If you plan to give testimony this evening, please stand and raise your right hand. Do you swear and affirm the testimony you give will be the truth, the whole truth, and nothing but the truth? If so, say yes. Thank you.
All right. Do we have our proof of publications for the items at hand?
We did not need that. We had
Did
two
we?
continuances and
Understand? All right. Any withdrawals or postponements? All right, pushing things through. Board disclosure. Has the board engaged in any conversation or communication with anybody affected? All right. Thank you very much. So move on to unfinished business. PZB project number 24-01500006 at 1724 North Lakeside Drive. Additional information requested by PZB board at August 7th meeting. On a variance to allow placement of a standby generator between the principal structure and the right of way. I think all of us kind of remember that. And I know that there were some issues with, I guess, the verbiage and what was in the code, what wasn't in the code, what was happening, the planning and zoning. So would the staff like to enlighten us on some of these items?
Mr. Chair, would the board like us to go through the entire presentation again or cover the items that?
I'd say we
that the
covered the
memo
items. I
covers?
mean, the reality is everybody knows, we feel pretty comfortable about what it is. And I think you had some resolution to deal with about your position. So if you could guide us through what we need to hear.
Okay, my name is Karina Campos. I'm the Senior Community Planner for the Department of Community of Sustainability. So this is in reference to PZB project number 24-01500006 for the consideration of a variance to allow the placement of a standby generator between the principal structure and the right-of-way. This is the site, as we remember. So on the August 7th, 2024 Planning and Zoning Board meeting, we discussed continuance for staff to provide additional information for additional code language that supports the validity of a variance requirement for the building official and fire department to re-review the staff recommended location to determine the feasibility of the generator placement regarding the National Fire Protection Agency requirements and to confirm the elevation requirements. So in the past, staff proposed or provided code language from the standby generator code section in LDR section 23.4-17. And in this section, staff identified that the generator would need a variance because this section doesn't state that it would be allowed in the front, only in the side or rear setbacks. So we have additional code language that we provided where it states that in the mechanical systems and equipment for existing residential structures in LDR section 23.4-16 that the placement of the mechanical equipment shall be allowed in the rear or side setback and or between the main structure and a public street if there is insufficient space to locate the equipment outside of the setbacks. So the staff analysis is that there is sufficient space to place the generator at the southeast corner of the property, all while remaining out of the setbacks. So the fire department, they re-reviewed it. They kicked it over to the building official who has the jurisdiction for this review. So the building official indicates that the generator may be placed in the staff recommended location of the southeast corner of the property. As the NFPA 37 requirements state that the generator must be at least 5 feet from operable windows and doors, must have an 18-inch clearance from existing walls, and must have a minimum setback of 3 feet from fencing and landscaping. Let's switch over to the elevation conversation. This generator again is 48 inches long, 25 inches wide, and 29 inches in height. Staff initially cited the pending FEMA base flood elevation figures, which would require the concrete pad to be 4 feet thick and would place the overall height with the generator as 6.5 feet. However, the map changes are not effective until December of 2024. Therefore, the site can use the current FEMA flood map height elevation requirements, which require a 1 foot concrete pad and an overall height of 3.5 feet with the concrete pad and the generator if it were to be placed in the front where the applicant is proposing. Here is a boundary survey of the property that was provided, which includes the elevations. This is the proposed site plan that was provided. This is to the west side is where the applicant is proposing their generator. Staff is indicating here to the rear is where the generator can be placed. From the property line to the building itself is 15 feet. Here's a photo of where the applicant is requesting to put the generator behind, they mentioned behind the rocks that are behind the bushes. This is the area where staff is recommending or saying that the generator could be placed at and remain outside of the setbacks. And also meet the NFPA 37 fire requirements. So in conclusion, the additional code language that staff cites indicates that the mechanical equipment can be placed between the right-of-way and the structure if there's insufficient space for it to be placed anywhere else. But staff states that there is an alternative area to place it in the southeast corner of the property, all while remaining outside of the setback. Our original variance analysis indicates that the project only meets one of the variance criteria, not all 4. So therefore, staff is recommending that the proposal not be approved or the variance request not be approved. But if the board decides to approve it, we have added conditions of approval to require screening and noise control, which I can upload here, but it's also in the staff report.
Can you back to the previous, previous.
Is this in the way?
Is the applicant here? Yes, the applicant is here.
It's been a while. Good evening. My name is Wes Blackman. I'm a planner, certified urban planner with CWB Associates. And had a nice meeting with Karina and Scott on Monday. The property owner, Ken and Barbara Campbell, are here tonight. I think Barbara was here at the last meeting. In fact, I watched the video twice. The second time was on a time 1.5, so I could get the gist of it. But it did go on for quite a while, and there were lots of questions. And I'm glad that the staff put together this clarification memo regarding height, because that was an issue. At one time, we were up to like 10 feet or something in the front yard, and that is not the case at this point. We're at 3.5 feet, which is easily screened by landscaping. Just in the future, I don't think it should hold up this case, but what this memo also does is it puts us here legitimately saying we have the right to ask for a variance for this purpose, for a piece of generator equipment between the house and the road. There was some question about that. I would note that section 23.416 was changed in May of this year. And it was only then that last sentence, mechanical systems equipment are not permitted to be located in the front setback of any property. And I'm just sharing that information with you, that when you address the code again and some discrepancies and so forth, you might want to tighten up or include generators as mechanical equipment.
That was May, you said May this year that was enacted?
Mhm.
Okay, but it's in place now, you're saying?
Pardon me?
It's in place now.
Yes.
Okay.
So, and the Palm Beach County Fire Department, you had concerns about that. They actually like the western location, which is in front of the house, between the street and the house, for access purposes, in case something happens there. Most importantly, we met with the neighbors, and you should have 3 letters of support in your packet. One from Mr. Heath at 1718 North Lakeside. His son's bedroom window is right above. They have a 2-story house above, and I have a picture of that if you have questions, but it's pretty near the property line. And it would be noisy. We have to remember too, that when these generators are operating, everyone's generator is going to be operating. And I remember when I lived through Francis and Jean, I didn't have a generator, but I sure knew all my neighbors did when I had to sleep with the windows open. So, just showing you the proximity of the house next door. Can you all see that? So that is essentially looking over the staff's preferred location. And we have a letter from the property owner saying that they are happy and support the location between the structure and the street. And likewise for the person across the street, and likewise for the person to the north, the property owner to the north. And just to review here in terms of the variance criteria. The special circumstances here are that it's a very deep lot and not very wide. And you pass it before you know it, essentially. So there's a very small view corridor there. You really have to be looking for this property. And the generator location is about 60 to 70 feet from the required setback, which is 20 feet from North Lakeside. So we think that's a unique characteristic. Also having a 2-story building so close to the south. That's a residential structure and bedroom windows above. The strict application of the provision of these LDRs would deprive the applicant of any reasonable use of the land or building. That's a pretty hard standard for anyone to meet. You have given variances for sheds. It's not required that you have a shed on your yard, but it sure makes life convenient if you have a crowded garage. So what this is doing is, in the case of a hurricane or a natural disaster of some sort where power is not available to the house, they would have a working generator that will come on automatically. The variance proposed is the minimum variance, which makes it possible the reasonable use of land or building. In this case, it's a generator, and it's as close to that window, the front window on the west, that you can be, according to the building official. And staff agrees with this one, that it meets the criteria, and the granting of a variance will be in accordance with the spirit and purpose of this chapter and will not be unduly injurious to contiguous property or surrounding neighborhood, nor otherwise detrimental to the public welfare. And we agree with staff on that. So when we met with staff, we started with the conditions of approval, and the property owner, Ken and Barbara, are satisfied with those. They can meet the conditions, and we ask for your approval. Thank you.
Good evening.
Good evening.
You mentioned the fire department about accepting it in the front and the easy access, but they're not the ones that make the decision. Both the building, our building official and county fire said that it could be installed on the side yard and meet the requirements.
Well, it also said that the fire department preferred it facing the street and visible from the street too. And I can find out where that is. Yes. At the top of page 3 of the new memo, Palm Beach County Fire Department indicated that the ideal location of the standby generator would be the front west side of the property, between the principal structure and the right of way. So, and they're the ones in the field. If there's a fire, if something's going wrong, they're going to make the decision right there. They're not going to wait a week. Any questions? Or the applicant, the property owners are here, and would you like to say something?
Mr. Chair, just also, I want to let you know that the building official is also here tonight, if you have any questions for him.
How are you? Are you done, Mr. Blackman?
I'm done unless you have questions.
Not at the moment. No,
Okay.
thanks. Would you like to hear from the building official?
So you have any questions? Do you have any questions specifically for me about the locations?
I do, and I think there'll be some people on the
Sure.
board that might as well. And I think I have a couple of questions for the staff as well. Obviously, the big issue here at hand is that there are very few generators, if none at all, in the front of houses around Lake Worth. And I guess there are several reasons why they're asking for it, but from your opinion, from the building department opinion, is there anything wrong with the recommendation from the staff?
I didn't see anything wrong with the location where it was at. You had plenty of clearance with 15 feet to get your 5 feet from the house, 5 feet from the property line, and
Right.
still have the generator in that location. So it would meet the NFPA 37, being that's 5 feet from any open window directly into the house. So it could achieve that at the front or the side. I mean, building department, as far as the codes, it's a non-issue being in either location, but it does work at both locations.
Both locations. Okay.
Correct.
The only thing that I worry about is that the fire department is, it's fine. It's great that you have the endorsement of the fire department. The issue is that they're not planners. And one of the things, I guess, the big worry that we would have is that by approving something like this, it would set off a chain reaction of people putting generators in the front of the house. And that begins an issue with a type of planning LDR problem that we may have, and it would go outside of that. And meeting one of four of the criteria is very different for a variance, right? Like a variance should meet all four, from what our legal counsel could chime in on that as well. So there is a big thing with that. Things are more isolated in the back. Obviously in the front, it becomes more of a public issue. And that's why I think a lot of them are put in the back, right? And it becomes a planning issue, not a fire issue so much, because the fire department could deal with it in the back or in the front, or a building issue because you say it works in both places. But it's a question of driving down the street and hearing a couple of roaring generators, right? So I mean, I'd let my other board members chime in on it, and
I don't have any question. I don't think this is a building code issue. I think that it does meet the requirements either way. I agree with you. I don't think that that's
Correct.
necessarily the issue. I do have some follow-up questions with regards to code, and so I don't have any other questions for the building
Okay.
official.
does anybody else have for the building official? Thank you very
Thank you.
much.
Thanks.
So if I, yeah, so
Mm.
in general, when I look at this, I do agree with Mr. Blackman that there is a unique characteristic to this lot, and it's the setback. Most lots in Lake Worth are set back about 20 feet from the street. This is set back 70, 80 feet back. So this is like way back off of the street. So that alone, as an existing structure, I think qualifies for consideration of a variance if you met the other conditions. I think that is a unique characteristic of an existing structure within the city. With regards to the code, in general, I still think that, I know we're doing a cleanup tonight, and I just would like you to kind of put an asterisk by this the next time that a cleanup comes before us, that we look at this language, because I know that we're being presented that the 23.416, which is the mechanical systems, is kind of a supplement to this, but the generators is 23.417. So really they're two separate sections, and they say repeat language. So I don't know if I think there are being defined as separate things with separate requirements as written under the code, as I see it right now. And I think we looked at the mechanical as supplement to compare. And if we compare the language, basically under 23.6 or 23.4-16, it essentially is saying you are allowed to put a generator in the side setback or the rear setback. If you go to 23.7, it only allows that if you can't put it within the buildable lot. So to me, the actual standard for a mechanical equipment is more strenuous than it was for a generator. And the question that came up before is, in 23.417, it only basically says you may put it in the setbacks. And there was discussion of, does that mean that it's allowed in the buildable area of the lot and also in the setbacks, or are you only allowed to put this in setbacks? It doesn't make sense to me that that would be saying you can only put this in setbacks, especially when it doesn't say you can put it in the rear yard, and it says you can only put it in the rear setback if there's no alley. If you define that, if you look at that language with that strict of an interpretation, you would be saying that you can never put it in the back of a house, because you can't put it in the backyard, and you can only put it in the rear setback if it doesn't have an alley. So I think the way that I'm interpreting that is that it would be allowed anywhere in the buildable area of the lot. Now, 23.416 says you can only put it in the front yard. And again, so we have to distinguish between a front setback and a front yard. It says never in the front setback. The front setback is the first 20 feet. So they're not proposing to put it in the front setback. They're way outside of the front setback. And under the more stringent requirement, 23.416 for mechanical systems, which basically doesn't allow you to put in the setbacks either, unless you don't have room, right? You can't, whereas the generator, you can automatically put in a setback even if you have room on the lot. So to me, 23.16 is stricter than 23.417.
23.416 actually lets you have mechanical equipment as close as 18 inches to a property line, as long as you have that space to have the maintenance. So there is a little bit stricter in terms of distance from property line for generators, obviously, because, you know, they have a little bit more of a dangerous output than like an AC compressor. But it is less strict in the sense of how close it can be to that setback. We had interpreted, and we do interpret it as mechanical equipment is general, and then because generators are that extra level of consideration, that we need to talk about, you know, when they can run, how having that further distance from the setback, that it has, that 17 almost acts as a supplement to 16. That's how we, as staff, have been interpreting it.
Okay, so you're saying that 6 at 17. So from what you're saying, where it says may be located in, like 17 just basically says generators may be located inside setbacks. 16 says it can only be inside setbacks if you don't have area on the buildable lot, right?
Mm-hmm.
So you would say that 16 would apply, and the only way that you could go into the side setback is if you don't have room on the buildable lot, then you could put it in a side setback, and then you're subject to 17 as well.
Yes, that's typically how we would approach it if someone comes and requests, you know, they've got plenty of room in the buildable area, but they're trying to put it in the setback. We would request that they move it out of the setback if they have the space to do so.
Okay. So I think that would be good clarification instead of, you know, even if we just move 23.417, you know, it'd be 23.416B or something. So it's not a completely separate section. If it's underneath that section, then it would be clear that, but as it's written right now, it does look like it's two separate standalone requirements.
Yeah, yeah.
From a variance perspective, again, I always find some of this stuff where it's like, if you don't have room to put it there. And I think those are always kind of weird requirements because they could propose to build a gazebo there. And then they could come in and say, oh, we no longer have room at this spot where you wanted it. Now we're allowed to put it in the front yard. And that
Could
just,
be a strategy.
yeah, I mean, these things, so it's, and when you're
Okay.
70 feet off the road, you're 70, I mean, you're putting this thing 50 feet off of the road, and generators don't run. I mean, we're thinking about these generators like they're big commercial generators that are, you know, that we would lose on a construction site, or your portable generators. But the requirements for the less than 65 decibels and the landscape screening would all still apply. You're talking about, you know, my parents have one of these out in Wellington. They don't live here in town, but when it turns on and runs, it's not a loud piece of equipment that's running. And if the neighbors and everybody involved in it is saying that they would prefer it not be near their window and be in this 60-foot stretch between the house, I think that we have the leeway here to provide a variance, and I would support it.
Question, now on the variance, could you go through the one part that it would meet the variance and then the three that it wouldn't?
Actually have those documents. So we indicate that it doesn't meet the first three where there's a special circumstance or condition that exists which are peculiar to the land or building for which the variance is sought and do not apply generally to nearby lands and buildings. And this is not the result of action of the applicant.
And you don't think this 70-foot setback would meet this criteria? I mean, 70 feet is definitely a special circumstance for Lake Worth properties to be set back that far, and they didn't build a house, so they weren't responsible for that.
But they do have space for it on the side. A relocation.
I understand that that's one of the next criterias, but a special circumstance or condition, having a 70-foot lot setback would meet a special, that's special in Lake Worth.
But it's
That's not
also
common.
similar in that area. The adjacent properties, most of the properties near it are not at the 20-foot setback either. They're set back a little further. So it's
Can we
similar.
just
in nature.
hear like the three things? So just, I want to hear it. That's it. And then we could speak all we want. And Wes, you can come up and talk all you want, but Ms. Campos, could you please speak?
Sure. So
Thank you.
the second and third criteria is similar. The strict application of the provisions of these LDRs would deprive the applicant of any reasonable use of the land or building, which the variance is sought. And three, the variance proposed is a minimum variance, which makes possible the reasonable use of land or building. We're saying that the strict applications of the LDRs will not deprive the applicant's continued use of the existing single family home, as there is a suitable location for it to be placed somewhere else. Number 4, where we're saying they do meet, the granting of the variance will be in accordance with the spirit and purpose of this chapter and will not be unduly injurious to a contiguous property or the surrounding neighborhood, nor the otherwise detrimental to the public welfare. So in this section, we acknowledge that if it is in the side, it will be closer to the adjacent property than if it were in the front. So in the front, it would be separated the most from the adjacent properties. So we mentioned that it does meet this criteria. So this is the only one out of the 4.
Out of the 4, okay. Mr. Blackman, would you like to
Okay.
mention and enlighten us on your,
Well, as a certified urban planner and having been around for 40 years, I can supply competent and substantial evidence. And even if the staff says it meets 1 of 4 criteria, if I say it meets 4 of 4 criteria, you can also base your decision on that. And as far as 4, which staff says meets the criterion of not being unduly injurious to the contiguous property and so forth, we have letters from our adjacent neighbors saying that they're okay and prefer the front location to the west. So taking that into consideration, the staff recommended location would be worse than ours that we're proposing. And then going back to number 1, special circumstances are the depth of the lot and the narrowness of the lot and the fact that the building is so far back. Number 2 is a very difficult one for anyone to meet, as we discussed. But the code is affirmative in saying and inclusionary in this aspect. In 17, saying that property owners are permitted to have generators as an accessory use. So that's pretty unambiguous. And the minimum variance it's about as close to the house as you can get without running afoul of the building code. So that's my take on it. So we think it meets the 4 criteria and it's better for the neighborhood, and staff will be incorrect as far as their recommendation and the staff report related to their recommended position.
Good.
So thank you.
thank you, sir.
Can I make a suggestion that the board here that we go through item 1 through 4, 1 at a time, talk about it, then go to 2, talk about it, then go to 3, talk about it, and then go to 4, talk about it?
Would like to do that?
I have a question for Ms. Linehan. Can you put these 4 criteria in context? Because I know they're in the code, but it's my understanding that these 4 criteria also come from United States takings law. And so my question is this. I forget what's in Lake Worth Code. Typically, these 4 criteria are something that the city has to win on. And if they don't, denial of a variance could be considered a taking. That's kind of how I'm thinking of it. But the code appears to say that the applicant for a variance must win each prong. But I understand these 4 prongs are not, when they were initially created back in 1985, that was not why they were created. So can you just put these prongs in context for us?
Do my best. So my recollection of variance law is that the goal of any land use code, any zoning code, is that the properties in your community comply with the regulations in your code. Variances were created for special circumstances where you cannot meet the requirement of the code. And so when you cannot meet the requirement of the code, what are you supposed to do? You meet these 4 criteria, and if you meet these 4 criteria, you can get a variance from the code where you can do something that's slightly different, just a little bit different, just enough to allow you the full use of your property, even though you can't comply with the code as it's written. So that's why the conditions are very strict for variances. when you can meet the strict requirement of the code, you're not supposed to be granted a variance because you're supposed to comply with the code. So the variance is for when you can't meet the code. So a special circumstance or condition of the lot, you're looking at something that is created not by the applicant, that is the existing lot that prevents the applicant from complying with your code as written. When you're looking at whatever part 2 is, so the strict application of the LDRs, they cannot meet the strict application of the LDRs. It's impossible to meet for this property because of the way the property is set out. So would that strict application prevent them from using their property, from the reasonable use of their property? So there are certain things for single family residential property that you can determine to be reasonable. In Florida, a lot of times they say a swimming pool is reasonable for a single family home. So you would be able to consider a variance for that. So I think it's arguable that a standby generator is included in the reasonable use of the home in South Florida. But do the strict applications of the LDRs deprive the applicant of having that use, or can they meet the strict application of the code as it's written? These are the type of determinations that you're working with when you're looking at a variance.
So should we, that was, I just wanted to hear
sure.
what she said. So should we go through each one?
Yeah, I guess so. Mhm.
I mean, I tend to agree with Dan and Mr. Blackman that I understand it's not a true outlier lot in terms of strict definitions, but it is a outlying lot in the fact that the setbacks are so large. It's a waterfront lot, which I think is, not in a aberration in Lake Worth, but it's certainly not the majority. So I tend to agree with them on that prong. A peculiarity prong.
And that particular thing we have used as justification for prior variances, where a house was set far back and they wanted to put a swimming pool in the front yard, which wouldn't typically be permitted, but this board has approved it because of the extended setback that the house had. So I think that condition 1, I believe is met by this lot. Condition 2 is really, everything is condition 2. Right.
Let's hear what everyone says about 1, though. Because if,
Yeah, I can agree with the way the house is set on the lot. I think even where I don't live on the intercoastal, but the way my house sits way back from the street. And there is no backyard at my house. I couldn't do it, and I'm in the hood. So I wouldn't be able to, I'd have to do it in the front lawn too. So.
My biggest thing with the first one is, from what I'm hearing, and it's odd because I know everybody has different opinions, right? But is there really a difference? A building official came up, basically said we could have it in either place. What I'm really seeing about the special circumstance is why then would the planning staff want it in the, if it is allowed in the front? Is it against the LDRs? Is it against it? So please just enlighten us, because that's where I'm looking for this special circumstance, because I'm hearing from a lot of people that it's okay, right? So where is it now? Is it a planning and zoning matter that basically says, okay, and if you could just, that would be the special circumstance for me, because now we are going against something that we're not supposed to be doing. So.
Right, it would go against the LDRs. That's why staff could not approve it. It would need a variance based on LDRs, not our opinion.
Mhm.
So the LDR says it cannot between a main structure and a public street if they're it can only be between the main structure and a public street if there's insufficient space.
Okay,
locate the
that's where
equipment.
that's what I'm not hearing here. Okay, I'm hearing everything else, that it's allowed, that it's okay, and then it's pushed back. But now the LDRs are saying it's not allowed between the front structure.
But I think that's why they have to ask for a variance, because the LDRs don't allow it
Right.
outright. So they've, applied for, paid for and applied for the variance and.
If there's no other place to have it, but there is another place to have it.
Oh, I see what you're
See what
saying.
I'm saying? So.
Yeah.
Yeah, so there is another place. So the LDR is basically saying, sure, if you're up against the wall, please put it somewhere else. But now they do have.
But that's a different prong though. That what you're doing, the impossibility of another location, it would deprive them of reasonable access to the land. If we're assuming that a generator is necessary to your enjoyment of the land, then I think what you're saying goes to a different prong rather than this first one.
It's a special, I was thinking of special circumstances and conditions and peculiar to the land, so. It's not very peculiar, because what I'm trying to say is that you have a place to put it, it's not peculiar, you know what I mean? It's not peculiar.
I see what
There's
you're
a spot.
saying.
That's why it hits this one. So,
And just to be clear, the staff recommended location would meet the LDRs.
okay, that would meet it, so
It would meet
we're
it.
following our rules, and planning and zoning like everybody else, okay.
Wes Blackman again, and it is entirely within your power to grant a variance. Even though, and base it on the rationale that I presented.
We
And-
understand that.
And you're not actually starting a precedent. I was told by the property owner that apparently the next door neighbor has a generator in their front yard. So it seems to be at least a local trend. So what I would do, and just stepping back from this for a moment, is I do think this code language needs tweaking and working, especially 17. And but that's what we're following on. So yeah, that's why we're and we ask for your approval.
So does code enforcement know about the other generator next door?
Looking right now to see at least from 2002 till now, we can see that in our record system.
I understand.
Did you?
Anyway, well,
I
that
moved
was my 2 cents. I just wanted to know where the deep root cause and what special circumstances and, conditions, the existing conditions would do that. And that's how I'm interpreting that, but.
Yeah, so on this item, I could lean towards the special circumstance because of the lot size.
Well, I'm sorry, I disagree. I think as long as there's a choice of places and that the generator can fit well on the side with the 15-foot clearance, I cannot go on board with that right now.
Yeah, do you have any?
I mean, I've said, I think that we have the leeway to grant this. The one that's a struggle to come across is the next criteria. The first criteria, I think it does meet. The second criteria is the criteria that says strict application of the LDRs would deprive the applicant of reasonable use. And so that's where, are we depriving them of reasonable use of the land by requiring them to put it in the back?
Right.
And I think that, that's where things get, to me, we're talking about variance. I still think that there's enough ambiguity within the code where it's not even clear to me that this requires variance, but I understand that staff is interpreting that way, and I don't really know enough like how we address that. But, if 23.417 is not a subsection of 23.416, and we're purely looking at 24.17, I don't think that 17 excludes the placement in buildable area anywhere on the lot. But I know staff is interpreting that way, and I don't want to go down that rabbit hole.
Yeah.
Again, I think I would really like to learn more about variances, because I know I have, as part of my professional career in other areas, applied for variances with multiple different municipalities, multiple different areas around the state, and we've been granted some you know, some waivers for some square footage requirements on new construction. We've been granted waivers for the number of driveways onto a street, all of which, you know, we could have adapted, but it would have made the project worse, not better. And I understand that it wouldn't have deprived our full use, but somehow variances are approved all around the state every day that I would argue don't meet this standard. And that's why I'm a little bit, you know, that's, I don't know if it's just, that's just what it is, but,
I would say a waiver does typically have different standards than a variance. Those are typically intentionally easier to grant.
I mean,
Um,
variances. I'm sorry.
gotcha.
I'm
You're good.
specifically talking about variances granted by a quasi judicial, but that issues variances, and they've done it for multiple things like that because it, you know, they look at it as it helps. And in this situation, you've got two locations. You know, a variance would allow one. You don't need a variance for the other one, but the other one is seems to be putting it tightly in between two structures. And it seems like the front location is the preferred location for a number of reasons, and that the residents support it. It's not going to negatively impact anybody. And to me, I feel like it's the right thing to do. So that's my position on it.
Yeah, I don't think this application does not, you know, satisfy prong two. But at the same time, I'm not convinced that these four prongs are not what a court would use to analyze whether a city's denial of a variance was an unlawful taking. So, you know, based on the situation, the neighbors, the fact that it's that the fire department, if anything, prefers the other one. I mean, they paid for the variance, they applied for the variance. I'm comfortable with a variance in this situation, even though two is not, you know, 100% met. I think, like Mr. Blackman said, that's sort of what this board is for. The applicant wants to pay all that money and, you know, drive the issue, then I think we're allowed to, you know, grant such a variance. And in this situation, I haven't really heard any solid reason not to. I know that's not the burden as far as what staff, you know, that's not maybe the 100% correct analysis under the Lake Worth Code, but, you know, this is a continuation meeting and I still have a lot of questions. So I'm in this situation, I'm comfortable granting the variance.
Number three? See number three?
Before we move, I just got a quick question. I know this one really isn't a topic, but I'm also looking at constructability. It sure does seem like it's a lot easier to construct that in front of the house than at the side of the house.
I think so too. Yeah.
So three is up on the screen here. So, right. So basically if you accept the two that it's depriving them, then three is what's the minimum change? Well, the minimum change is moving it to the front yard.
Yeah.
You know, with yours. So I think that if you agree with two, then three falls out, and staff has already said that they meet criteria 4. I'm prepared to make a motion to approve unless there's further discussion. We'll see if it passes.
We're discussed out. We already discussed. And you're the best on variances, don't say that.
So I think we do have here.
Do you want
Bringing it up here. Okay, so I'm going to move to approve PZB project number 24-015000006 for a variance to allow the placement of a standby generator between the principal structure and the right of way for the property at 1724 North Lakeside Drive. I believe the application meets the variance criteria for the reasons that we have stated in this discussion.
Okay, do we have a second?
I'll second.
All right, so I guess all in favor?
Aye.
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 No.
No.
Mr. Chair, I'm sorry. Was the motion included, did you include the conditions?
The conditions.
Yes, I would include the conditions for the 65 decibel and the vegetation screening.
All right,
Yes.
thank you.
Just to be clear, you're including all of the stated conditions, not just Any particular ones or?
Sorry, let me make sure. I don't think that I saw anything.
There you go.
Okay.
I don't think so. Yeah, 65 decibels, that's just hospital quiet. They all come like that.
Yes, I think including all of the conditions.
I think, does the seconder agree?
Yes.
And then revote,
Okay, revote.
just to make sure all the conditions are,
Okay, so at this, so your vote is
In favor.
in favor,
Against.
In favor.
against.
In favor.
In favor.
Okay, vote passes. Thank you.
Very much.
Next.
Thank you.
All right, PZB project number 24-005-00007. A conditional use permit request for a 3,600 square foot minor vehicle service and repair use located at 1969 10th Avenue North. This item is a continuation from July 17th PZB meeting. Okay, staff, would you have anything? Okay. Quasi judicial. This is a quasi judicial hearing to hear. I just read out the PZB project number 24-005-00007. So do board members have any ex parte communications or personal investigations to disclose? No. All those giving testimony, please raise your right hand and be sworn in by the board secretary, please.
I think
Has anybody not been
I'm
sworn?
an attorney. I'm not going to be a witness, but I am going to present. Do you want to swear in?
Okay. All right, under the quasi judicial rules, we will hear from the city first, then the applicant, and then the affected parties. When called, please state your name and the name and address of your property you're speaking on behalf of. After the applicant speaks, we will hear from the Gaslight Business Park Condominium Association represented by Lauren and Kian Law. Thank you. City staff, can you give the department?
Yes, we did have a presentation.
Again, my name is Karina Campos, the Senior Community Planner for the Department of Community Sustainability. So the project we're about to discuss has one party registered as an affected party and is not in support of the project. The affected parties as defined in section 23.1-12. One shall be allowed to present evidence to produce witnesses and to cross-examine witnesses produced by others. 2, may appeal final decisions of staff, Historic Resources Preservation Board, Planning and Zoning Board, or City Commission. And 3, may file suit to enforce the provisions of this article should the city fail or decline to do so. Quasi judicial hearings shall be conducted generally in accordance with LBR section 23.2-16. So the project was scheduled to be considered by the Planning and Zoning Board on July 17th, 2024. The project was requested to be continued by a potential affected party and the applicant. The board voted to continue the item to the September PZB meeting. The proposal is under PZB project number 24-005-00007, a request for conditional use permit to establish a medium intensity minor vehicular service and repair use that will occur within a 3,600 square foot commercial building. The site is located on 10th Avenue North. It's just west of I-95 and it is within the mixed use west zoning district. Here are the existing conditions of the site. The applicant, there's 3 buildings. The applicant space or unit is in the rear, right here. Please note the condition or the existing conditions of the site at the rear. We'll be discussing this further regarding parking. Here's a site plan or survey that was provided by the applicant. The highlighted area is the location of the unit for the applicant. This is the area that I noted where the parking was removed and a drive aisle was removed and a landscape island, which staff conditions to address this. And this was done without a permit. Here's a floor plan that the applicant provided. They have an existing tire wholesale business in the unit and are requesting to add minor auto vehicle service repair. And they have office space. The staff analysis indicates as condition, the project or the proposal meets the comprehensive plan, strategic plan, meets city LDRs, and is consistent with the general findings to harmony with the LDRs. It meets the specific findings for all conditional uses, and it meets the supplemental regulations for vehicular and repair facilities. Therefore, staff is recommending the approval of this proposal with conditions. The main condition here is to require a minor site plan application to restore the parking in the rear, the landscape island, and the drive aisle, to designate 9 parking spaces to meet the supplemental regulations for vehicular service repair uses, add additional landscaping to the south perimeter and the west of the site, and to coordinate with Public Works in regards to the dumpster enclosures of the site. We have additional conditions of approval that are standard for vehicular service repairs. This is considered minor, so outdoor storage, overnight parking, work outside of the unit is not permitted and is conditioned as so. This is additional supplemental regulations that we conditioned in this as well, where it includes hours of operation, work, landscaping, and the parking spaces. This is standard conditions. I do want to note that our city engineer for water utilities did also provide a condition of approval that the applicant provide evidence that they have a oil or water separator or apply for a building permit to install one prior to the issuance of any business license. And that concludes the presentation.
Okay, the applicant? Would you like to give your presentation?
Good evening, board members. While we don't have a formal presentation, first of all, let me introduce myself. I'm Megha Kumar. I'm an attorney with the law office of Alexis Gonzalez. I'm here tonight representing the applicant. While we don't have a formal presentation, we do understand the conditions for approval, and my client is willing to abide by those conditions. As you will see that there is some opposition to this application. So in order to, I guess, streamline the procedure for this evening, while we don't have much to add by way of the conditions that are being presented, if the association would like to, Gaslight Business Park would like to, present their arguments as to their opposition, then I would like the opportunity to respond, if that would be okay with you, just to streamline the procedure.
Okay, sure.
All right, thank you.
Okay, Gaslight Business Park Condominium Association, represented by Lauren and Kian Law.
Yes, good evening, everyone. My name is Josh Lauren. I'm with Lauren and Keen Law. We're here today representing the Gaslight Business Park Condominium Association. I believe you all got a copy of our written response, which had a couple of exhibits attached to it. I'm not going to go through that all word for word, but I just want to touch on a few brief points. Despite being required to by the association's declaration, Romano Tires never came to the association before submitting for approval for this conditional use permit. Since that has happened, the association has since met and has voted to deny their application to the board in order to be able to perform these sort of minor vehicle repair services on the property. Additionally, and as described in our letter, the work contemplated by the conditional use permit, the minor vehicle repair and service work, things like changing oil, changing brakes, changing tires, changing shocks, particularly the oil changes, implicate the association's common elements in the association property. I can go through them in more depth, but a large portion of the conditions which have been placed upon this conditional use permit, things like the oil and water separator, things like the site plan amendment, are all things that do not, that infringe upon property that doesn't belong to Romano. This is association property. This is common element property. Romano has no right and no authority to dig into the concrete slabs to install oil and water separators, to perform work on the water and sewer lines in accordance with whatever the city engineer deems appropriate for this kind of work. Additionally, the parking situation is another thing entirely. The declaration forbids any sort of assigned or reserved parking for units, which is again another condition that the city has imposed upon this permit application. I want to go through. First, we do dispute that approving this would be in accordance with the city's strategic vision. We don't see how approving this would add anything to the tax base or influence the supply and expansion of jobs. And it's the association's position as the responsibility to speak for all other members of the Gaslight Business Park condominium, that approving this work and requiring the association to go and perform all these improvements at a shared expense to everybody else in the condo association would be very detrimental to everybody else's business. So all of Romano Tires neighbors are going to be forced to bear the cost of the improvements required for this conditional use permit. And that's something that the association simply will not accept and will not approve. So even theoretically, if the board approved this conditional use permit today, the association still would never grant Romano the authority to go and perform all these improvements that are required in order to meet the conditions here. We do believe that approving this would have a negative impact on the commercial viability of other tenants in the condo association. Again, we're not only talking about an enormous assessment, but we're talking about changes in our insurance. We're talking about having people's business disrupted by large amounts of work on the property, site work on the property, having, the oil and water separator and the utility lines dug up on the property. All of this would cause enormous damage to the other remaining members of the condo association. We disagree with staff's assessment that the proposed conditional use is not anticipated to impact the surrounding area greater than the uses permitted by right. Romano, by right, is not permitted to do any of these things under the declaration. Romano does not have the right to perform any of this improvement work. Romano does not even have the right to change his business without the association's approval. Right now, this is a wholesale tire business. They buy and sell tires wholesale. The nature of that work is very different from the nature of the work contemplated by the minor vehicle repair work. Very different, requires not only all of these other conditions, but would greatly impact all of the condo association's other members. Conditional use permits, section 23.2-29, subsection A, require an individual review of their location, design, structure, configuration, density, and intensity of use. And here, I think when we look at the location and the structure here, I mean, this is a structure built in 1985. The improvements that are going to be required to get the utilities up to code and to get oil and water separated here are going to be massive undertakings that it simply would be an enormous burden for the other condo association members. You know, the minor vehicle service and repair work is subject to additional supplemental landscape standards under the code. So setting aside anything that else with the property, this sort of work would require the association to go above and beyond anything else that's required in doing certain site work and certain landscaping requirements, again, at a shared cost to everybody. You know, it's been determined, and the reason why we have to go through this conditional use process is because things like minor vehicle repair work have the potential to substantially have a substantial adverse impact on neighboring properties. And we have to keep in mind that each one of these units, each one of these bays is its own property, and the association property is its own property. So we're talking about infringing upon the rights of dozens of other parties in order to accommodate Romano Tire's desire to change its business use, a use that's very different from what was initially approved by the association when they purchased this property. You know, there's a conditional use here that would require the property to come into compliance with the Palm Beach County Unified Land Development Code governing wellfield zones. All of this would be an enormous undertaking, again, at large cost and expense and damage to the remaining members of the condo association. I'm happy to let the applicant do a presentation. If you have any questions, I'm also happy to answer those.
I have a question.
Yes.
So we are
Well,
looking.
if you will, please,
Oh.
there's presentations first, then an opportunity for the parties to cross-examine each other, and then board questions, okay?
Thank you.
Okay, is there any public comment cards to be read into the record? Okay, well, the next one I have here, it's
Thank you for accommodating this change in order. While council's, presentation sounds very compelling, respectfully, I must say that it doesn't fully represent what Romano's intentions are with this permit. When one applies for a permit, the permit affords the opportunity to do many things. However, Romano entered into this and filed this application with the intention, a very simple intention. They are a wholesale tire business. However, all they intend to do with this permit is installing tires. They've never once thought of doing oil changes. They don't intend to do oil changes. They have at the most, brakes, other items that basically what I'm hearing is that the association's main concern seems to be with the oil changes. And I'd like to first and foremost clarify that Romano doesn't intend to do oil changes. So if for whatever reason there needs to be an additional condition or an agreement between the association and Romano that Romano will not perform oil changes, Romano is fine with that as well. However, these issues that are being raised by the association are essentially between Romano and the association. This should not factor into the board's decision. And after a very thorough review of the property, of the surrounding areas, and the suggestion for an approval after much thought, after diligent research, that this application should be approved. The association's internal concerns regarding costs, expenses, et cetera, should not be factored into what the board decides this evening as far as whether or not Romano can be approved for this conditional use permit. I'd also like to add that Romano doesn't, to the extent that I haven't already stated it, Romano does not intend to install hydraulic lifts. This is going to be a very simple operation. In fact, it does not intend to do any work outside the unit. Everything is going to be done inside the unit. Additionally, when we're talking about requirements such as the parking spaces, I believe the map, the original site plan shows that the lines for those parking spaces, and that's all that is, being asked is to repaint, to restripe those spaces. That area, if you saw the current condition of the property, that space is still there. It's not being used for anything else. It literally just needs to be painted. There was a landscape buffer there that was part of the original site plan. It has been, again, as mentioned, removed without permits. All that the city is requiring is for the property to be brought back into the condition that it is required to be. So I don't believe that granting Romano this permit is imposing a greater burden on the association if all they're being asked to do is comply with the original requirements. As previously mentioned, Romano is willing to comply with all of the conditions that have been proposed. To the extent that there are any objections or issues by the association, again, I'll reiterate that Romano is willing to work with the association to work those out. For whatever reason, as mentioned, this is common area. These are common elements of the association, part of which Romano has an ownership interest. While the association may oppose this, at the end of the day, if you do approve this permit, it will be up to Romano in order to submit that, the minor site plan. They will need to work with the association in order to do that. So we shouldn't, the process shouldn't be hindered today as far as the approval, and if they're not able to comply with submitting the minor site plan, then that's on Romano. But this process today should not be hindered by what you've heard today. Thank you.
Okay,
Brief response.
yes.
Just a couple quick points I want to address. Number one, aside from any variance from the original site plan that the association may or may not have to do anyway, there are additional requirements that are listed here that are specific to a conditional use permit for minor vehicle repair work. Supplemental landscape standards that go above and beyond anything that the site plan would have required that are implicated here. That's number one. Number two is that we disagree that this is solely an internal matter between the association and between Romano. We believe that the purpose of this hearing here today is to have Romano's neighbors, the fellow property owners, voice their concerns, and the association is here representing 20 other unit owners. Romano has a 5.2% interest in this association. So we're here today to express the concerns of all these 19, 20 other businesses here that are going to be greatly impacted by the contemplated improvements that are going to be required in order for you to approve this permit. And finally, I would just like to say that what you're granting here today would allow Romano to perform oil changes, would allow Romano to perform brake changes. And I'm not aware of any mechanism here today where the the board is permitted to carve out and create its own special use permit just for changing tires, as long as Romano promises not to change oil and take away all of these additional conditions that would be required in order for you to ordinarily approve this. I believe that what Romano has applied for is a minor vehicle repair work permit that would allow them to change oil, that would allow them to change brakes, that would allow them to change brake fluid. And all of these things impact the association and the association property and the common elements and the 20 other unit owners that are a part of this condominium association. Thank you.
Go ahead.
I'd just like to clarify two things. While the association states that they're here on behalf of the other unit owners, the other 94-point-something% unit owners, their letter itself states that it's the board that met and denied this application, denied this request for an application. I do not believe that 3 board members represent the entirety of the unit owners when this decision was made, just to clarify that one item. Additionally, when they say that the declaration does not allow, the association's governing documents do not allow for this use, I disagree. That is not what I've seen, and that's not, and no specific provisions have been highlighted today that go to that. I would just like to point that out to the board when they're considering this. Thank you.
Thank you. Now, for any public comment, or anybody from the public have cards to read into the record? Okay, does the city staff have any questions of the applicant or affected parties? No. Does the applicant have any questions for the city staff or the affected parties? All right. Does the affected party have any questions for the applicant or the city staff?
Not at this time.
Okay, we'll go into deliberations. If there are no additional questions, I'll close the public hearing and ask the board members to discuss the request.
Might have skipped the board question section, number 14.
Oh, I'm sorry, that's 14. Do the board members have any questions of the parties?
Yeah, I do have a question for the affected party. So we're here for a conditional use permit. And the criteria for a conditional use permit are outlined in the staff report. And as I understand your objection and your basis of having affected party status, it's completely based on the condominium declaration. You know, to the extent that it's not, I heard very little argument about the conditional use permit criteria and what's in the staff report. And I think that's because this forum is really designed for analyzing those issues. This is not circuit court where you can file for an injunction to prevent them from doing oil changes or prevent them from, you know, opening up shop, or you can sue for damages. This is planning board and we're just looking at a CUP. So, I mean, I think I understand you applied for and received affected party status. I'm not sure if they objected to it, but I mean, I hear what you're saying, but I think you have another forum for your objections, and I don't think that it has anything to do with what we're doing here tonight. If you can respond to that, that's the question.
Yeah, I mean, listen, I hear what you're saying. I think if we're just taking a purely technical view of what they're asking at 30,000 feet, there's nothing in the planning and zoning rules that necessarily are going to prohibit this. I think that where our argument flows from under the rules is that the board here has an obligation to evaluate how this conditional use permit affects other neighbors, affects other residents. And I think what we're here today saying is that this has an enormous adverse impact on those other unit owners. So if you want me to get into the weeds on why Mr. Romano isn't allowed to do this under the declaration, I understand that's sort of a different issue. But if we're just looking at purely the board's obligation here. I think the board has an obligation to hear out the concerns of the other condominium owners in the Gaslight Business Park and the potential impact that this will have on their business. I think if you look at the conditions that the city is imposing here, these are all things that directly impact and adversely impact not only the association, but every other unit owner in the Gaslight Business Park. You know, I may not be sitting here today with 20 other unit owners behind me, but the board has been voted in and empowered specifically for this purpose to speak for the remaining unit owners. And we have an obligation to protect other people's property and other people's businesses. And I think if the board were to deny this today, it would be on the adverse impact to the other unit owners in the condominium park.
I hear you, okay, and we could beat this to all night long, but I agree with Zaidi. I mean, I said as an expert witness for a lot of law firms in a lot of different types of cases, but everything you mentioned today was condo law, okay? There's a lot of things that have nothing to do with what we're doing here today. So we're looking clearly at, and it's not a 30,000 foot view. I think we're looking at what a conditional use permit is, and it would require certain parks to do things. Now, I think it's very silly of the applicant, right, to go through this knowing that you could sue him later, but that's not for us to do. That's up the road, okay? So everything you mentioned tonight, I believe is strictly a condo dock type of situation. And I think it's not so, structured toward that. Now, you mentioned you don't have 20 people here. Boards tend to be very autocratic. I understand they're voted in and everything else, but it would have helped if you had 20 other people here. So there's a lot of things like that that you have to look at, but we're not a condo law organization. We're a planning and board, planning and zoning board.
I understand that, but when you're looking at this application here to perform this work in this one unit, you're now requiring conditions that go outside the scope of that unit, that go outside the scope of Mr. Romano's
Do that to every park that we go to. And then that's up to you guys to decide whether you're going to allow him to do it or not and take it to court. But for us, we just see the buildings and the landscape and the traffic and the things that happen. So, and the uses that are there. So that's what we're doing here today. And you're talking about something else.
See, I agree with that because I'm on a board of directors of a condo association and understand about common elements and understand about vote and understand about everything you're saying about that. But again, it's condo law, and that's why I'm not here right now to decide on your common elements or your board voting on this or knowing what the other 20 people or businesses have to say about this. So everything you said about condo law and HOAs, common elements and changing that around and everything else is true. But again, it doesn't, the way I feel doesn't affect me right at this time because I have to vote on something that doesn't affect condo law. Thank you.
So that was really my only question. Does anyone else, just so we don't deviate from the procedure, does anyone else have a question for him? Because it's not, the affected party gets 10 minutes to speak and then they get to answer the questions and then I think they have to sit down.
Yeah.
I'm not trying to cut you off, but you answered my
I would
question.
sort of be curious to know how the board feels about, the adverse impact to every other business here by the work that be required.
We don't have to answer that.
And we don't have the board. I mean, it's the board here. I don't have 20 people here speaking and anything else. So.
I think we should go back to the procedure probably.
Yeah, we might have questions for staff.
I just have one question for staff. From site plan approval, the applicant for site plan approval would have to be the association, right? A single tenant can't make a site plan application for a site that they don't have control over, right? Like if I'm applying for a permit, I need the owner to sign off on things.
The property owner always has to either be the applicant or have given agency to the applicant.
And in this case, if you look at it on a property appraiser, the affected areas for a site plan would be, it would show the condo association of the owner of that property, right?
Whoever the owner is, I have not looked at this property to see who owns all the different parts and pieces.
I think what Dan's getting to is that a lot of times when you're in a condo
Mhm.
and you get a permit, you'll have to have a letter from the condo board approving it, right? So he's asking if that was more or less something like that you'd have to go through.
Yeah, I mean, so essentially I can understand how, especially for a use permit or for a building permit, if you're a condo owner and you're building inside of your condo, but when they then have to go in for a site plan, and they're,
I imagine it is the association, but I have
you
not
haven't
checked that, so I
verified.
don't want to say that
okay.
is absolutely the case.
When I don't have a lot of experience with this with condo associations, but I have done stuff within like planned communities or planned developments, mixed use developments. And typically if I want to do something that impacts the site, I'm required to bring it's one of the conditions that I provide to you is basically the approval from the PUA, the POA, whoever it is for that.
You could add that as a condition to this if you wanted.
I mean, I thought it would already have been a condition. I don't want to step outside of it.
Complicated as
Dan,
it is.
I think your question is getting at the fact that this dispute is not ripe yet.
Right.
We don't know who is going to even be able to come in and apply for the actual business license to do what they want. They can, I mean, I don't think we're looking at a conditional use permit. Our job is not to adjudicate a dispute between a condo association and, I mean, the fee simple owner of that spot. So it's possible the site plan would be just their little, unit. Because, a PUD, a planned unit development, is one common owner versus they would at best just have, claim to a lien or foreclosure or something, but they don't own that. See what I'm saying? I don't think this is ripe and it's not appropriate for us to.
The only thing I think that would be odd in this whole situation is that the application wouldn't have the blessing of the condo association with because usually it does. But anyway, if that's not the process, it's not the process. It is in many other places. So that's it. So would the board like to further discuss our condo situation? So I'll close the public hearing and ask the board members to discuss the request. Here we are.
Well, I already gave my opinion and I agree with Mr. Sasha Bashan on that, that again, being on the board of directors of an HOA and a condo association, I know all the different rules and things that have to happen, but I don't think that, in my opinion right now, is that we shouldn't get involved with the condo law and stick to what we have here.
Absolutely. The one thing that I would like to discuss, and I mentioned it a minute ago, was that even if we approve this, which it seems like there's really, given the conditions and everything else, there really isn't anything that is adverse. The issue would be then you now have a further, much harder uphill battle with the condo board, whether it be changing common elements and doing things and changing the landscape and everything else, which has nothing to do with us. I hope you understand that, because that would have to do with you and them and how you deal with them. But our approval means nothing for that. Our approval is basically saying, if you're going to do these things, this is what you have and what you have to do. Will they let you do it? Well, that's a whole other matter. Has nothing to do with this forum. And I hope the council understands that as well. You get it, right? Okay. So, and I'm kind of not sorry for anything, because the reality is we're just trying to do our job, right? And we're going along with that. And I hope everybody's going into this with their eyes wide open, because it doesn't look like this is the end of it right now. Okay. So, okay. Does anybody have a motion?
I move to approve PVZ project number 24-005-00007 with staff recommended conditions for a conditional use permit request to establish a minor vehicle service and repair use based upon the competent and substantial evidence provided in the staff report and in the testimony at the public hearing.
We have a second.
Second.
All in favor?
Aye.
Thank you. Yeah.
Thank you, guys.
Thanks. Thank you. Next. I know these things don't work.
Thank you.
But the thing is, but it's stupid. No, they're going nowhere.
Thank you. Thank you.
Thank you.
Take it easy.
I mean, the thing is, where are they gonna go now? Huh? Oh, yeah, no, she was very respectful. She was very to the point. Yeah.
Oh, yeah, they're not going
It's not going on, but that's why I told them, I said, our approval, whatever happens here tonight, it has nothing to do with what, nothing, they're not gonna get it, so it's okay, but it's fine, and they can't try to use our approval. I would tell them again, we have nothing to do with that, that has, usually though, even to get a building permit. The associates, oh, yeah. And
Yeah.
I have it in my hands. After I read the caption, I can hand it to you.
That'd be great.
unbelievable.
Mr. Chair, would you like me to read the caption of the ordinance that is next on your agenda?
Okay, our prestigious building official.
All right, this is ordinance 2024-15, an ordinance by the city of Lake Worth Beach, Florida, amending chapter 23 land development regulations, article 7 floodplain management, and providing for severability, conflicts, codification, and effective date.
So we have new floodplain maps being issued by FEMA that have to go into effect on 12/20/2024. They've adjusted, obviously, some of the areas up because they've taken into account wave action.
Like
from
that
the-
generator coming up about 4 feet.
Exactly. Now, there's a lot of those areas that were AE6 are now going to be AE9. So
Right.
yeah, about a 3-foot increase in some of the areas, and it pushed inland a little bit further.
It does in some places. I was just about to mention that. Everybody thinks it's a line and it's actually not.
It is
And-
not.
And that's.
There's little neighborhood
Yeah.
areas where it goes up individual streets.
Absolutely. And I think people need to understand that because it's.
Absolutely.
Yeah. All right, out of line.
So are we just approving the map?
Approving the map, and then there is some changes in that. We had some information in our building code that was now included in the actual newest building code, so it was redundant that it was in our ordinances since it was already in the building code.
Will the building code automatically get adjusted back to this map? Will this be kind of like common law for the building department and construction?
When these go into effect,
Mhm.
then we will be
It'll
enforcing those.
supersede, right.
They'll supersede the previous maps.
Yeah.
Correct.
And they're going to affect December 20th.
That's correct, December 20th.
I don't think there's a whole lot to do here except.
No. Yeah, it's,
Yeah.
FEMA's FEMA.
Yeah.
It's
We
fine.
want to have FEMA coverage.
I reject.
Yeah.
Let's go to
So-
Washington.
Yeah.
So I'll go ahead and
Yeah.
move to recommend to the city commission to adopt the proposed LDR text amendments included in ordinance
second?
2024-15.
Second.
All in favor?
Aye. Thank you.
Next one.
All right. Next is ordinance 2024-13, an ordinance of the city of Lake Worth Beach, Florida, amending chapter 23 land development regulations, article 1 general provisions, division 2 definitions, section 23.1-12 definitions, article 2 administration, division 2 procedures, section 23.2-19.1 public neighborhood meeting, article 3 zoning districts, division 1 generally, section 23.3-6 use tables, and division 2 residential districts, section 23.3-7 SFR single family residential, section 23.3-8 SFTF 14 single family and two family residential, section 23.3-10 MF 20 multifamily and two family residential, section 23.3-11 MF 30 medium density multifamily residential, and section 23.3-12 MF 40 high density multifamily residential. And division 3 mixed use districts, section 23.3-13 MUE mixed use east, 23.3-14 DT downtown, section 23.3-16 MUFH mixed use federal highway, section 23.3-17 MUDH mixed use Dixie Highway, section 23.3-18 MUW mixed use west, section 23.3-19 TOD East, Transit Oriented Development East, and section 23.3-20 TODW, Transit Oriented Development West, and division 4 Commercial Districts, section 23.3-21 NC Neighborhood Commercial, and division 5 Industrial Districts, section 23.3-23 AI Artisanal Industrial, and section 23.3-24 IPOC Industrial Park of Commerce. Article 4 Development Standards, section 23.4-4 Fences, Walls and Gates, section 23.4-10 Off-Street Parking, section 23.4-13 Administrative Use and Conditional Uses, and adding a new section 23.4-26 Pools, and Article 5 Supplemental Regulations, section 23.5-1 Signs, and section 23.5-3 Nonconformities, and providing for severability, conflicts, codification, and effective date.
All right. Thank you, Elizabeth. So for the record, Annie Greening, Principal Planner for the City of Lake Worth Beach. This is our fall round of LDRs. So similar to what we did in the spring, it's kind of a mix of everything that we've seen as we've been using the code as staff. So mostly housekeeping items and minor changes. There we go. All right, so we've got a whole bunch of areas being changed or altered slightly. A lot of it, those zoning districts, basically from single family residential through IPOC, the most part is just correcting and being consistent with the roof overhang encroachment. It just is very long because we have to amend all of them individually. So the highlights of what we're doing, we are adding a definition for accessory storage, clarifying how much of that use area can be considered accessory. Just making it clear for our applicants when it's accessory and when they need to actually get approval as indoor storage as a principal use, and revising some definitions to allow for that. In terms of the use table, it's a mix of revising things to match the text in our code, correcting some things that got overlooked, like the specialty brewery and distillery, or museums and environmental nature centers that were allowed in the text, or similar uses were allowed. But for whatever reason, when those got added, it wasn't put through to the use table. We also are creating a low intensity indoor storage use permitted by right in the industrial zoning districts. This is something that previously would require an AUP, but we've determined that it would be a pretty minor impact in those zoning districts. So under 2,500 square feet would be permitted by right and not require those additional processes. In terms of the public neighborhood meeting, it would be revising it. Currently, you're allowed to have it in person, online, or a combination of both. We would be revising it to require that some component of it is in person. So you could still do a mix of in person and online, but you could not hold an online only public neighborhood meeting if you're required to do so. The roof overhang encroachment, just again, correcting and clarifying the maximum 2-foot encroachment of a roof overhang into a side setback, making that consistent across. And then build to line. In these two zoning districts, MUDH and TODE, we are clarifying that requirement for the front and street side build to line. The language was a little bit confusing previously, and we've gotten that feedback from applicants. So we're trying to make that super clear going forward. Fences and gates, clarifying that permitted height in industrial uses, and then revising and clarifying the gate heights and location for residential, commercial, and industrial. So the big change here is the location of any gate leading to a driveway, parking area, parking lot. Previously, if it was an electronic gate, required across the board a 25-foot setback to prevent stacking of cars in the right of way. We got direction from the commission to revise that to 5 feet, regardless of gate type, if it is leading to a parking area or a parking use. We did leave in the code the provision that the city engineer can determine that there's a need for additional setback if required to prevent stacking. So we still have the ability to prevent people backing up onto Dixie or wherever if we need to. Parking, creating a definition and standards for ribbon driveways. They've been allowed, but just trying to make it clearer to people what those would look like, what the standards are. Creating standard dimensions for motorcycle spaces. Again, they were previously allowed, just clarifying it for our applicants. Pools, we got a lot of feedback over the last few years that people have had a hard time understanding from our current code what a pool setback would be, and what a setback would be for, you know, a tile at grade deck versus a raised wooden pool deck. So creating this new section to hopefully be more user-friendly, have all of that information right there for our applicants and contractors. And then housekeeping items, just revising some definitions to clarify setbacks for semi-permeable surfaces, things like that. Correcting a use approval that was incorrectly noted for places of worship. Clarifying sign area requirements for multi-tenant buildings, just so it's clear how much each tenant can have, and then clarifying requirements for what is considered a non-conforming lot of record. So we know it's a lot, it's a big ordinance. So if you guys have any, you know, line by line changes or any particular sections you want to talk about, please feel free to let us know.
I've got 3.
All right.
Keep it simple. 3 easy ones. I got line numbers for you.
Okay.
So 330 was the line number in the attachment. So that's referring to the impervious and pervious. And so it's talking about semi-pervious, and there is a exclusion there that basically says that semi-pervious material needs to stop. I think it's 18 inches from the property line on the side and rear, or it's 1 foot. I think that you should add an exception in there for rear property where it's adjacent to an alleyway. Oftentimes we have semi-pervious as parking off of an alley. And so you don't want to have a green strip in between your parking space and the alley that you access it.
If it's parking, that's always been the process there. If it's required to, you know, access your parking space, it's
just that this specifically
Yeah.
says that you have to stop at a foot away.
Mhm.
And I think it should say, that should be clarified to say, unless there's unless it's parking being accessed by the alleyway. The second one that I have is a little more, 745 to 747. And this specifically is talking about single family homes and that their fences cannot have gates accessing to the municipal golf course. I know that that's a common thing in those single family lots currently. I have friends who live there. Their kids are playing ball. Somebody throws a ball over the fence. They open up the gate, walk out to the golf course and retrieve the ball, the Frisbee. the toys. They also 4th of July fireworks. People will go out there and set up lawn chairs. It's a very common thing that people have gates onto the golf course from their single family homes, just like people have at Bryant Park or anywhere else. Is there a reason why that's being added to the code as a not being allowed?
It has been something that we've had direction from Director Waters for a while to add that provision, having unimpeded access to the public golf course through not the public entrance. He's concerned about people having just come and go access to that. Whereas, you know, they would normally need to come in through the standard entrance.
I think it's liability issues there as well.
to city
you
park.
That kind of seems
parks.
like more than housekeeping, though.
Yeah.
It's more than housekeeping.
You know, that seems substantial. So I mean, yeah, I see what he's saying. That seems like maybe something that should be city commission. Yeah, but I mean, I feel like this is a huge, I understand a lot of work went into this. My wife used to be an urban planner and she did the code revisions. So, but like, you know, typically these code revisions are something we just accept. But I think that that should be distinguished. That doesn't strike me as something that's appropriate for like a big blank, you know, a big batch of amendments.
When we do our staff report for the city commission, we will reflect that and make that an item that they should consider.
I think, yeah, that's
Yeah, and unless there's like, because you have Bryant Park, you have other public access where people go right out of their backyards into Bryant Park, and that's not something that we're excluding areas from. So I don't know why that this just seems kind of weird. And of the people that I know, maybe 4 or 5 people that I've been to their house on the golf course, and I think every single one of them has a gate out. I think that's a pretty standard thing. So to say that all of a sudden we're going to stop that without that being really brought to the public and there being a reason why, other than just we don't like it anymore. I think it would that could derail your whole easy, simple thing. And so just, yeah, I would not recommend adding that to the code unless there was some specific reason from a liability standpoint that I personally don't believe exists. 816, 817. So this is regards to the handicap spacing. I always am a little bit reluctant to put specific language that's already governed by like the universal federal accessibility standards. So you've already got your UFAS requirements for handicap accessible spots. They go further to say how many are van accessible versus regular accessible. And there's a lot to it. So I understand, you know, having language specifically in the code. I usually prefer to refer to another standard, but in this case, I would just ask that you identify that the access aisle can be shared between 2 parking spaces. You're going to have it in there because it's not every parking space doesn't require an aisle. They're allowed to be shared between the 2 adjacent parking spaces. And I don't want that to be misconstrued. Otherwise, everything looked great. Those were the 3 things that I made notes of.
I have an overall question. I guess over time, we've seen a lot of things that have been a little bit out of whack. For instance, the gate issue that we had over on the north side there, that was front, back, for all those things getting like, you guys keep a tab of these things and have like a nice little list that
Yeah, we have an Excel
somehow
spreadsheet.
updates these things.
Yeah.
Okay, I'm just asking because it would help, and because we find these things here, right? So it's nice to kind of pick them up and put them in there. That's it. Okay. All right, so do we have anybody else? We have a motion?
If I were to make a motion, I would make a motion that we recommend with the 3 changes. And I just want to see, is everybody kind of okay with that? What I said? Okay.
fine with that.
Just
No.
for my own, I'll be writing the staff report for city commission, so I want to make sure that I'm accurate when I'm writing this. The golf course gates, would the recommendation be to strike it from this and get direction from the city commission for a separate amendment?
Yes.
Okay, perfect. Thank you.
Okay, so I move to recommend to the city commission to adopt the proposed LDR text amendments included in ordinance 2024-13 with the 3 requested clarification modifications that were presented to the staff.
Second,
second.
all in favor?
Aye.
Aye.
All right, you guys have it. Any planning issues? There's always planning issues.
Actually, I have more department comments. Just
Okay.
FYI, this past Monday, all Department of Community Sustainability staff, managers presented to the city commission basically what our function is as a department. That we did that Monday night. It was a long night, but the city commission had requested that. So we were, for some of us on staff so far, this is a second or third meeting this week, and want to inform the board that we did that. And
Okay, that's good.
Annie and I presented our portion for planning and zoning to the city commission. Just as another reminder, we will want to know who can make the October 2nd as soon as possible. That's in 2 weeks. Right now, we have 5 items that will tentatively be on the agenda. And it's an important meeting for some of the land development regulations. We do have some more ordinance language to review. Right now, we have a conditional use permit, a townhouse project, and a replat. The replat is actually probably one of the more important items for this board to consider, because that's on a somewhat of a tight schedule to get it to city commission. So I wanted to inform the board of that October 2nd meeting, and please let us know as soon as you can if you are not able to make that.
I can be there for that meeting, regardless of the BYOB.
Excuse me, sorry, I just wanted to talk a little bit about something. I've been to a couple of CRA meetings lately. And it seems like they allow 1 or 2 of the people who can't be there to join on Zoom, and the board members do that. Is that something we can do? I mean, in case we don't have a forum and,
Well, it's my understanding they can join, but they can't vote.
okay.
So you have to be in person to
And
vote.
okay,
Yeah.
then that's, yeah, however you guys feel about it, but
I think there is an exception if it's a medical, it specifically has to be a medical, the state law says unless it's a medical reason why you're not there, then I think you're allowed to vote, but it may be subject to city charters as well.
send it in.
Board members in district past that have been granted permissions to do that, to join. At the time, it wasn't virtual, but it was.
Okay, that's fine.
Just a couple of quick items. So we will consider some of the recommendations and the discussion for land development regulation revisions. Annie and I are on a really consistent track for fall and spring rounds. And right now we're starting the spring round 2025. And also based on today's meeting as well, probably be very important to have some variance training or information submitted to the board. And even as we talk amongst ourselves, good idea to train our staff on the same, just so we can all get some more information on that and as we move forward. Thank you. That's it.
Okay, thank you. All right, so public comments. Guys want to say anything? No? Department reports. We're all good?
Yeah, I kind of covered that.
Okay. Board member comments? Adjourned.